Welcome to The Workplace, a podcast by CalChamber. I'm Bianca Saad, General Counsel for Labor and Employment with the California Chamber of Commerce. Hello, listeners. As we enter the stretch run of this year's legislative session, bills that relate to automated decision systems and technology, which we have colloquially termed AI, are still a hot topic. This follows up on the heels of both the filing of the Civil Rights Council, or the CRC's, Automated Decision Systems Amendments to California's anti-discrimination regulations, and the California Privacy Protection Agency considering its own automated decision-making technology regulations that would impact employers. Taken together, there is a lot on the table relating to employer use of automated decision systems. To discuss the CRC regulations and the status of two cost driver bills that are still pending, we welcome back Ashley Hoffman, CalChamber's Senior Policy Advocate for Labor and Employment. Thank you for being here, Ashley.
Thanks for having me.
All right, so let's get started with the regulations as those have been finalized and filed with the Secretary of State. So Ashley, can you tell us about these regulations and how they may affect employers?
So I think really the impetus behind the regs and what they do is to confirm that existing law does apply in scenarios where employers are using ADS. The regulations do expressly state that it is unlawful for an employer or other covered entity to use an ADS or selection criteria that discriminates against an applicant or employee or class of applicants or employers on a basis protected by the Fair Employment and Housing Act. So in other words, it is unlawful if you using an ADS results in a person or group of people, being discriminated against. I think a lot of times as we see ADS being used in hiring, that's probably one of the biggest examples of where there's a risk of that occurring.
Okay, great. And so what are we really talking about when we say automated decision making?
The regulations do have a non-exhaustive list of tasks that ADS perform in the employment context as examples. So something like an assessment to date, predictive assessment about an applicant or employee, measuring of an applicant or employee's skills, measuring of personality traits, something that maybe like resume screening, directing job advertisements. Sometimes we've heard of things like interview software, right, that analyzes facial expressions. And so some of those processes, I think, are the kinds of things that the regulations are implicating.
Okay. And so when we're talking about ADS, and now that we know a little bit of what that can look like, when we're talking about the CRC regs, what are really the takeaways for employers? Like, what's important for them to take away from the obligations that are imposed?
I think for me, looking at the regulations, it's really, as mentioned, confirming that if you as an employer are using ADS, it's very important that you are looking at the performance of those tools, right? Are you auditing its performance to ensure that it's not having, a bias, especially when we're talking about hiring? I think that we've heard stories, of instances where sometimes software, if you're running testing, you can see maybe it is screening out certain kinds of applicants, and so wanting to be very aware of that. And then also identifying what tools you have in place. How are you not only auditing the performance, but how they're also being used? For example, if it's making recommendations, is someone looking at those recommendations? And really, how can you kind of implement it to improve efficiency in HR decisions? But then again, also ensuring that you're evaluating the data, the results to ensure that they are indeed meeting the goals that you have.
Okay, great. Yeah, I like what you said about making sure somebody's reviewing it, like having that human behind what the tools that's being used. It sounds like that's a really important piece for employers.
Yes, exactly. And I think, when I look at these regs, again, my takeaway is you don't want to be caught in a position where, unbeknownst to you, maybe the ADS is unfortunately having a discriminatory impact and, I think trying to guard against maybe some companies saying, oh, well, it wasn't us, it was the ADS, right? You want to make sure that if it's your employee, and you're using the ADS, that, at the end of the day, you are responsible if discrimination under the law has been found to have been occurring.
Yeah, that's a really good point. Okay, so sticking with technology, one of the major tech bills that we're watching is SB 7 that proposes to regulate the use of automated decision systems for employment purposes. So what are the proposals that exist currently in SB 7?
SB 7 has a couple of different components to it. And I think it's important to note at the outset that SB7, except for one notice obligation, doesn't apply to applicants and hiring. It really is about use of employment. So first of all, there's a notice requirement, a pre-use notice, and there are some, accommodations in there. Of course, if the bill were to take effect, if you are already using some of these ADS, you would have until April to provide this notice, which has a couple of different components about, the nature, purpose, and scope of the decisions. It must be a standalone notice, but it can, be provided in something like an email or a hyperlink. There is a notice requirement, however, for job applicants if ADS is going to be used, for the job, right, on their resume, what have you, that they are applying for. And there's a couple of different options, again, as far as how you can provide that. Other major pieces of the bill, there's a laundry list in there about prohibitions, some of which we have some concern about. There's a blanket ban on predictive behavior analysis. One of the examples we use is sometimes you will have financial institutions that maybe use predictive behavior analysis to catch fraud that is used sometimes on consumers, but also can be used on employees. One, obviously a huge risk industry there, and want to make sure that your employees are acting, honestly and above board when dealing with folks' monetary accounts and data. There is a ban on, quote, primarily using it for promotion, discipline, or termination decision. Again, have some concerns about the restrictiveness there, just because, if you have an ADS, for example, that's pinging that someone doesn't have the right PPE on or is driving a machine unsafely or something like that, there may be scenarios where we do have to primarily rely, because you cannot have someone watching someone else at all times. There's also a post-use notice requirement where if you are using ADS in a certain decision, then there must be notice to the worker that is individualized. And there's also an appeals process that kicks in as well, which is really one of the first times we've ever seen, if maybe the first time we've ever seen an appeals process actually introduced into statute, which I know is a big concern from us, just coming from the employment law perspective, not only just because California is an at-will employment state, but also the way we read the language. Really, even if ADS is only used minimally, the appeal could be triggered. And so that's a huge issue, I think, just not only from administratively for a business, but then also really the precedent that that's setting in employment law.
Wow. Okay. So yeah, there's a lot there. There is a separate bill, AB 1018, that also addresses employer use of ADS as part of a broader approach. So what's different about AB 1018 from SB 7?
So to your point, SB 7 is really focused on employment, and I'd be remiss to also not point out that it also applies to independent contractors. So if you're listening to this and you're thinking, oh, well, we have a lot of independent contractors, they are included in the definition of worker. AB 1018 is not just employment, but a lot of other decisions, right, that are being made. In both bills, the way ADS is defined is it's anything that even just assists with a decision. So really broad. And that's consistently, I think, been our issues with both bills, is really the breadth there. Thinking about employment, AB 1018 is really focused a lot on the testing requirements, right? The impact assessments and things. And it did undergo recent amendments. And so there's an audit requirement, there's assessment requirements in there, even dating back to technology that predates the bill. So a lot of, work, especially for those who develop this technology. On the deployer side, those still have a lot of obligations. There's individualized post-notice obligations. There is the right to appeal. There's also, rights to correct. While the opt-out was taken out of 1018, those other two pieces are still in there. And so we do have a lot of concern, I think, about the practical implications on employers and what this means. SB 7 is really not, limited, or neither of them really are limited by size either. And so, you're talking about potentially big employers, but also small employers. SB 7 does include some language to try and kind of reconcile, if both were to be signed, that some of the obligations in 7 would supersede 1018. But again, that's really focused on the notice issues, not so much, some of the other language in there, again, in 1018, like, I'm thinking things like the right to correct or something, which also is in 7, but you're talking about, in some instances, potentially different uses, like hiring is still in 1018, but it's not in 7. And so I think this is kind of a long-winded way of saying, there's similarities but differences. And I think as we get closer to the end of the legislative session, some of this is going to need to be ironed out as far as exactly how employers would, if both were to get signed, for example, exactly how you'd comply with both.
Okay, so for those listeners who are familiar with the fact that CalChamber takes positions on bills and we have our affordability agenda and we have a cost driver list, are these two on that cost driver list?
Yes, they are. And, this is a third iteration of 1018. It was not on the list prior, but I think from our perspective, especially when you're adding in things like the audit requirements, we did have a lot of concerns really that actually some of the costs to be able to comply with this, did increase this year. Again, with SB 7, I think a lot of, that decision is the cost, the implication both on small and large businesses, but also really that appeals process and just introducing kind of this new concept into employment and the right to access and the right to correct. And if an employee were to make such a request, what does that look like, right, for both bills? And so just a lot of still concerns that we really have about the breadth of both and what it would mean from an administrative burden perspective on employers as they're trying to comply.
Yeah, so after hearing all that, I'm sure many people will want to track the status of these bills and stay in the know as far as what's going on. So can you let us know as far as, what is the current status and when might we know whether one or both passed the legislature?
Sure. So, both bills went through the committee process. They're in the second house. So what happens is every bill before it goes to the floor, if it is tagged fiscal, so it has a fiscal impact, it goes through the Appropriations Committee. When a bill has a fiscal impact over a certain amount, it is put on what is called the suspense file to be reviewed more closely by the Appropriations Committee. So at the end of the month, there will be a hearing in which each house kind of dispenses with the suspense file, and we find out what moves to the floor of the House for a full vote. So both of them are sitting on their respective suspense files. So you really have one of, I'd say, like three options. One is it gets held, right? It doesn't move forward. One is it does move forward, but it moves forward with amendments. Those can be amendments either put forward by the author or by the committee. And then the last would be that it does come out, but with no amendments. And so we will know at the end of the month, what these bills look like and if they are moving forward onto the floor. And then you will have the full chamber of the House that they are in be, set up to potentially bring it up for a vote.
All right. These are a couple of bills that we will definitely be watching closely on the compliance side of things because, as you said, there are a lot of obligations tied to those. So, Ashley, thank you so much for taking the time to sort out where we are in the world of automated decision-making and AI.
Yes, thank you for having me. And I think these are both going to be very interesting bills to watch as we head into the end of session.
And thank you, listeners, for joining this discussion on the workplace. Please share and subscribe to CalChamber's podcast by visiting calchamber.com.